Hi, welcome to My Court Coach. I'm Jaylyn, and I'll be your instructor as we navigate through Form DV-112, which is the waiver of hearing on denied request for a temporary restraining order. So the only time that you're going to use this form is if you want to cancel the hearing date that is listed on item 3 of your DV-109. So DV-109, item 3, and that's your notice of hearing. So this court hearing is scheduled on your request for the restraining order against the person in 2, the restrained person, and it has the hearing date, the department, the time, and even the address. So if you're wanting the court to cancel this and so that nobody has to appear at that hearing date, then you have to fill out this waiver. And the reason why people don't want to appear on a denied request for temporary restraining order is they feel, well, if I didn't get it on a temporary basis, which is a lot more simple to obtain, what is the likelihood of me getting it on a more permanent basis? And that could be sometimes true and sometimes incorrect. I mean, it really depends on every individual's fact pattern and circumstance. And so perhaps you got a partial denial, and that partial denial in your temporary restraining order and notice of court hearing was the orders that you were really hoping to get in your domestic violence restraining order. So an example of that is an order for removal from the residence. So you got the stay away and you got the no contact order, but the court denied your request to remove the other party from the residence. Well, in that regard, perhaps you just don't want to proceed with the restraining order. So it's a case-by-case basis, and you're going to have to make that determination for yourself. So in order to complete this form, the name of the person asking for the protection, which is you, needs to complete it. And the name of a person to be restrained, you write their name there. So the court wants to provide you with some notices. What is this form actually, so you can understand what it is that you're doing and you're not making any mistakes in terms of canceling the hearing. So it says some or all of the temporary restraining orders you requested were denied for the reasons listed on your notice of court hearing. And those reasons will be listed right here. Further explained for root denial or reason not listed above, the court will go ahead and complete that, or the court believes that there wasn't enough detail for the most recent incidents of abuse, such as what happened, dates, who did what to whom, or any injuries of history of abuse, or the facts did not show reasonable proof of past act or acts of abuse. So the court can use any of those reasons to deny some or all of the personal conduct and stay away orders. And the court can set the hearing, which they did on the notice of court hearing, and might make the orders you want after the hearing. So if you plead your case essentially a second time in person in front of the judge, and the court may grant your request. And if we went with the example of order for removal from the residence, the court can grant it at that time of the hearing. Now you're going to use this form only if you want to cancel the hearing on the DV-109. And if you want to cancel, then you have to sign this form and file it with the court clerk. If you do not serve the DV-109 and other papers on the person in 2. So it says do not serve these documents. If you do serve it on the other party, then you also have to notify them that you are canceling this hearing. So you have to provide them this document. If the person in 2 files a response before you actually file this form, then you may still have to appear at the hearing. So, time is of the essence, and it's best practice if you are going to cancel your hearing, either to do it as soon as you determined, and hopefully that determination happens before you leave the courthouse with your restraining order packet. If it doesn't, then it's best to try and get it done sooner rather than later, so that the other party doesn't file a response in case, sometimes people even file a response before even receiving the restraining order from you. They don't care to be personally served. They just feel anxious. They see that this is on the court's calendar. A restraining order has been filed. They go to the courthouse, grab the information, and file their response because they just want to be overly prepared. And so for those individuals, if they do that before you complete this form, then you can still have to appear at the hearing. Now, if the hearing is canceled, then the orders made on that temporary restraining order is going to end on the hearing date. So you may file a new request for temporary restraining orders on the same or different facts at a later time, however. So you must read this form. You have to understand that you do have a right to a court hearing irrespective of the denial of the temporary restraining order. And by signing below, you're asking the court to cancel the hearing that's listed on this DV-109. And you understand that any orders already made by the court will end on the hearing date. Signing it under penalty of perjury and dating it. I hope that you found this video to be helpful, and best of luck.